Welcome back to the University of Southern California Institute of Armenian Studies. This is the series we are calling After War, Before Peace. It began with the document that was signed, the Cessation of Hostilities document in November, and we have continued our discussions about the many aspects of this post-war situation that must be tackled if there is going to be a path to security and to peace in the South Caucasus, specifically between Armenians and Azerbaijan. Today's episode we're calling Instruments of Justice and Equity. And we're going at this from the perspective of the existing instruments, the possible instruments available within the international community for victims of war. Obviously, most of the time, those are the losers of the military conflict, in this case, Armenians. And we're going to speak with a political scientist and an international lawyer, both in Yerevan, to see how these instruments apply, if they apply, to this situation, and are they, in fact, being utilized. I want to first welcome Emil Sanamyan, my colleague in this endeavor. Emil Sanamyan is a Caucasus analyst, very familiar with the ins and outs of this conflict over the last 3 decades and far longer. Emil, welcome back.
Hello.
And our two guests. Dr. Irina Ghaplanyan is a political scientist, a climate negotiator, and a published author. She holds a doctorate in political science from the University of Cambridge. Her main areas of expertise are, and it's a list, political leadership, states in transition, climate politics, environmental management, gender in conflict, as well as security studies, and all of these apply to the conflict at hand. Among other publications, she has authored Post-Soviet Armenia, The New National Elite, and The New National Narrative, published by Routledge. Dr. Ghaplanyan served as Deputy Minister of Environment for the Republic of Armenia until fairly recently, and is currently teaching at the American University of Armenia. Dr. Ghaplanyan, welcome.
Thank you.
We are also going to be joined by Sheila Paylan, a public international lawyer specializing in international criminal law, humanitarian law, and human rights. She spent more than 13 years working as a legal advisor for the United Nations at various international tribunals, including the Tribunal on Rwanda and on ex-Yugoslavia, and on the Khmer Rouge trials, as well as with the Office of High Commissioner for Human Rights. And she's recently moved to Armenia to work with the government in this post-war transition period. She has published extensively on the subjects of genocide and crimes against humanity, as well as remedial secession, and the responsibility to protect, which tells you she's Canadian. Canada being where the concept R2P was born and has been presented and advocated within the international community, and we'll speak about that. Welcome, Sheila Paylan.
Thank you.
Those are the two probably longest introductions I've made in this series, and I did it particularly because the various areas of expertise that you two bring to this is ironically appropriate to the time and the period and the various things that you're each doing with government, in parallel to government, as civic initiatives. So thanks again. Let's start with the R2P principle, Sheila, because by the sound of it, it sounds like something that was made for this moment. Tell us what R2P is, and does it in fact fit?
So R2P is a principle that's only about 15 years old. It was, however, unanimously adopted by all UN member states. And it basically affirms that all governments have a responsibility to protect populations from mass atrocity crimes, both within and beyond their borders. So that is something, yeah, that's the novelty, because typically you would just, everybody has to take care of their own people and everybody has to leave each other alone, so to speak. So this is a somewhat different perspective on the traditional view of human rights, which is that states have a responsibility to protect their own populations from human rights violations. And this remains the first pillar of R2P, but then R2P takes it 2 steps further, so 2 more pillars. The second one is that the international community duty to assist other states in fulfilling their duty to protect their population.
Their own populations.
And the third, yeah, but like other countries take on this responsibility where, let's say another state is struggling to protect or promote the human rights of their own population, they will help them, maybe fund trainings or whatever,
And struggling is a polite word. And struggling is a polite word. Okay, got it.
Yeah. Well, the third is the most interesting and relevant to this situation pillar, and that is if a country is unable or unwilling to protect its civilians from mass atrocities, i.e. committing them or other, then the international community must take timely and decisive action to fill this protection void. So that's that interference that comes in. And this is interesting because it has like certain implications for the principle of sovereignty, which is this primordial principle in international law, one of these most unbreakable ones almost. So by adopting or affirming R2P, like all the states in the world effectively agreed to give up another little piece of their sovereignty. But, R2P is not a legal commitment, and I think some people get confused about this. It's a political commitment, so there's no real way to enforce it, and states can choose not to implement it. It's a moral and political commitment.
When you say states,
even when it is
when you say states can choose not to implement it, you mean both the state whose sovereignty is being approached, as well as the state that wants to take on or should be taking on the responsibility to do something?
Yeah, like if you have, you've signed on to a human rights convention, then you have, as a state, the state has an obligation that is enforceable or at least opposable if that state violates the rights of its citizens. But if a third country chooses not to intervene under R2P to assist a state that is actually violating the rights of its own citizens, there's no equivalent sort of procedure where you say, hey, you're violating R2P. It's not a thing that you can violate. It's something you can implement. But, it's not an enforceable or opposable instrument.
So really, this does seem to be tailor-made, because at the end of the day, a great deal of the complexity of the situation of the human rights of the Armenians of Karabakh, Artsakh, the war situation and the post-war situation, the human rights abuses, torture, mercenaries, now prisoners of war, not just prisoners of war, but perhaps they're political hostages now, not just prisoners of war. That whole thing has been untouchable because at the end of the day, Karabakh is within the territorial integrity of Azerbaijan. It is within sovereign Azerbaijan. Now, here is an international principle that theoretically would allow states that want to protect the values of democracy and human rights to actually step in. Yeah, Emil, am I going way too ideal here?
I think that I need to intervene right now. Just one point. The officials from Russia, from France, and at some point in the United States made it clear that Karabakh is not an internal matter for Azerbaijan, that it's an international issue. That's whole reason. There's a mediation mechanism, and there is a Russian military presence right now in Karabakh, in part to represent the fact that this is not an internal matter for Azerbaijan.
Well, it may be an international issue, but that does not mean that the sovereignty of Azerbaijan over Karabakh is being questioned.
In the sense,
but it doesn't mean either. Sorry, it doesn't mean either that nobody can do anything about it. Even if Karabakh is considered to be within the borders of Azerbaijan, that doesn't mean Azerbaijan can get away with certain real gross atrocity crimes. The question is, who's going to trigger?
Yes.
Not R2P. There are other mechanisms. There are other conventions and treaties and that give it, if a state wanted to bring this forward, they could.
Irina, do you want to jump in before I ask about those other instruments and the triggering process?
I just wanted to second Emil's opinion regarding Nagorno-Karabakh being really an international issue. And this was at the outset of the conflict. when Nagorno-Karabakh, Artsakh, has put forward its claim for secession. And then originally it was under the Miatsum movement, and then it changed. But from the very beginning,
1980s.
yes, in the 1980s, in 98 with the Karabakh movement, it originally was under the aegis of Miatsum, and then it was a clear act of secession. And in fact, Nagorno-Karabakh followed the same process as all of the other Soviet republics, and in the framework of the Soviet constitution at the time, requested its rightful independence. We need to stress that Nagorno-Karabakh, Artsakh, was an autonomous oblast, and it had a lot more rights under the Soviet constitution at the time than, for example, entities within other republics. So that needs to be mentioned. That gave the foundation for Nagorno-Karabakh, the Republic of Artsakh, to be also a negotiating side in the conflict at the beginning.
So, accepting the historical precedent and coming to the point today where we have international instruments that can, in fact, protect the rights of the people of Karabakh who were the victims of the military aggression that resulted in this 45-day war. Sheila, you were saying there are instruments. What are they? And how do, in fact, they get triggered?
Well, they get triggered if parties sign on to them. That is a very, very essential part. So I can tell you what the main one is, and you've already discussed it in a previous one of your panels, which is the European Convention of Human Rights. The application of the European Convention of Human Rights is in the European Court of Human Rights, and this court is active. It's already rendered quite a number of relevant judgments, even in relation to Artsakh. But when it comes to the last war, an interesting avenue now that's being pursued by both by Armenia, actually as a state now, to defend the rights of its population and of Artsakh against Azerbaijan, and vice versa. So we've got these two sort of counter interstate applications, and which, actually renders the process a bit more akin to what would happen at the International Court of Justice. So on February 1st, Armenia filed its first ever interstate application before the European Court of Human Rights, and it's claiming all kinds of violations, but they're all, of course, human rights violations. They can't be anything other than human rights violations that are contained within the convention. So, the court is not competent to monitor whether Azerbaijan or Armenia complied with the laws of war, but to the extent that during the war human rights violations occurred, which of course they did. I mean, that's, what was violated is up to the court to determine, entertain that. So there's, a whole host of violations that are before the court there. The other thing of note that Armenia has done was on November 11th, it notified Azerbaijan that the actions and policies adopted during the last few decades constitute gross violations of the International Convention on the Elimination of All Forms of Racial Discrimination. And sort of, without getting too much into the details, sort of, use this language that's held within the convention that if calling them to negotiations to try to get them to respect this convention, and should they fail to do so, that they reserve the right to settle this through a legal dispute in accordance with the procedures set forth in the convention, which signals that they might be headed towards the ICJ, the International Court of Justice.
Emil, Sheila, I'm going to ask Emil to jump in, because Emil and I talk often about the procedures that are available, the timeline, and on the other hand, the facts on the ground, the environment, the atmosphere, and the need for some sense of security and peace soon. Emil, does this help? Does hearing these processes, is it part of what is going to make the reality on the ground a little more stable?
we'll see about that. What we have had so far is, of course, the international law in the abstract, and then we had actual practice of international law. When it comes to the responsibility to protect, even though in the abstract it's been adopted at the UN, it has been practiced. Prior to that, in a number of interventions, not just in the 20th century. If we go back as far as the 18th century, Russia cited its responsibility to protect its merchants in the Caucasus as the first reason to intervene in the Caucasus, and its merchants included both ethnic Russians and Armenians and Jews and others. So this has always been a part of the international toolkit to cite a particular danger to a particular group to intervene on their behalf. And most prominently in the last couple of decades, we had the case of NATO intervention in Kosovo on that basis, and then Russian intervention in Georgia with regard to Abkhazia and South Ossetia, again, citing need to protect local populations. In this case, again, as we heard from Russian officials, from Putin, from Lavrov, they don't consider Karabakh an internal matter for Azerbaijan. They consider that to be an international issue. That's the reason Russian forces are there. That's the reason Russian government applied pressure on Azerbaijan and on Armenia to agree to a ceasefire that would entail Russian peacekeeping mission in Karabakh. So we have this practice of international reactions to need to protect the populations, and that really is the key thing. That this issue is on the agenda of the Russian government, of the European governments, and the U.S. government. Of course, from the ground perspective, what's been accomplished so far is not sufficient for a secure environment, and the practice at international courts, such as the CHR, has been notoriously very slow. If we look at the history of ECHR judgments, they took many years to come to some kind of resolution.
Irina, you're the political scientist here. The time frame. On the one hand, governments will do what they will do. That is, all of the procedures that Sheila cited are going to be done and followed. I mean, especially if they began as early as November 11th, the day after the ceasefire. At the same time, however, politics is politics, and for a lot of these processes to start at all, and B, to get any traction, the political wherewithal, both from the country that's doing the filing as well as all of the other international players, has to be there. What is being done? What is being done to prepare, nurture that political environment?
By that political environment, if you mean some type of compliance by countries that are before the court, I would say that indeed, ICJ and other international courts are unfortunately do not have the instruments of enforcement, but they are created to seek some type of justice for injustices committed against a group of people or countries or what have you. So when we talk about particularly, and as Sheila mentioned, the International Convention on Elimination of All Forms of Racial Discrimination, we have precedences in this part of the world, particularly from Russia, from Georgia, from Ukraine, taking these other countries before the ICJ in the framework of the International Convention on Elimination of All Forms of Racial Discrimination. And I think this sets a very important platform for this particular conflict, because if we are truly speaking outside of the legal language or the legalese, today it is illegal for anybody to be Armenian in Azerbaijan. So if you are a US citizen, if you're a Canadian citizen, and you have a last name that's IAN, or if your first name is Armen, you're barred from entering Azerbaijan. And that's just the tip of the iceberg. The extent of xenophobia and racial discrimination against Armenians is that on par with what we've seen in the 1930s and 1940s. 1940s in Europe. So we really need to call things by their real names. And that's what really today is promoted and incentivized by Azerbaijani government. We saw this recent awarding of the medal of one of the military high-ranking military in the Azerbaijani government who allegedly was committing horrible crime, morbid crime against the civilian. So this we've seen also with the case of Safarov. He was a convicted murderer in Hungary, and then he was glorified as a hero in Azerbaijan and given all sorts of awards, etc. So this is a practice officially on the part of Azerbaijani government, and we need to have Azerbaijani government stand before the court in the framework of this convention. Because today, when Azerbaijan claims that Armenians in Artsakh will live peacefully with Azerbaijan, that really is not the reality on the ground. The reality on the ground is it's illegal to be Armenian in Azerbaijan. So by no means can we force an entire republic to be subjugated to the rule of Baku when this war showed that 44 days of war, it was a deliberate and indiscriminate shelling of civilians and civilian infrastructure to ethnically cleanse Artsakh of Armenians.
Emil, go.
I just wanted to add that in terms of shelling, I mean, the shelling was actually pretty discriminate as far as, precision weapons being used, and occasionally was intentionally targeting civilian infrastructure, but primarily did not target civilian infrastructure. But in terms of areas that came under control of Azerbaijan, particularly in Hadrut, in Shushi, essentially the very few people who stayed there for reasons of them being very old, not wanting to leave their homes, they were entirely, completely either killed in the most brutal ways or taken as hostages to be exchanged for Azerbaijani prisoners. So that's the options that exist, either some kind of way of keeping Azerbaijani forces out of Armenian populated areas, or if they cannot be kept out, then those areas cannot persevere. I mean, Azerbaijan is not presenting an option where, say, for example, now that they have come in and taken a part of the Armenian populated Karabakh, for the population there to stay and live. That's just not an option presented by Azerbaijan.
So Sheila, did you want to jump in, or shall I? Oh, go ahead.
Yeah, I just that as far as I'm concerned, everything I've seen in my career, everything I've learned is that, this talk of peaceful coexistence and none of it can happen without justice. You cannot envision peace without justice. That's not everyone would agree, but most people would, because impunity is part of this problem, and that goes for everybody. The behavior will repeat itself, and that's why it's really important to trigger and launch whatever legal mechanism that is available to make sure that this never happens again.
Sometimes there's discussion of sanctions, and sanctions are, to the extent that I understand them, individually applied. You don't apply them against, well, there are different kinds of sanctions, obviously. But if, for example, the Magnitsky sanctions that the US initiated with Russia and Russian oligarchs in mind, if sanctions were to be brought to bear, they would be targeted individuals. Azerbaijani leaders, military, political leaders would be targeted. And to the extent that today a great deal of the environment that is not making the beginning of security and peace possible comes from the statements of and the actions of, as Irina, you just gave examples of, military leaders. Are these sanctions, individually targeted sanctions, Magnitsky sanctions, available in this situation? And I'm saying this on the assumption that, based on a lot of material in social media and elsewhere, Azerbaijan does not mean every Azerbaijani. That there are people in the region who do want coexistence. But if the leadership continues with this punitive, vindictive tone, I don't know how you get to justice and equity and tolerance and stability and peace. Are sanctions a possibility? individual sanctions?
Individual sanctions are a possibility. They would require a significant amount of work that would envision working in terms of political advocacy, working in terms of legal diplomacy, both bilaterally with countries as well as on various international platforms. This would also entail exhausting domestic jurisdiction on many cases and trying those war criminals in domestic jurisdiction and then taking that as evidence to other platforms. So absolutely, there's just a lot of work that needs to be done domestically and then taken out to international platforms. Unfortunately, Armenia is not a party to the Rome Statute. That is, we are not able to take these war crimes to the International Criminal Court. But we are able to put together a good case and take it to, why not, Security Council, take it to other entities. And even if it will be vetoed by any of the members, we can at least request official inquiry. We can at least hold Security Council members accountable and before the world, knowing all well that these war crimes have been committed, and there's full evidence in place to conclude that.
If I could add one little nuance about the Rome Statute, some people may have forgotten, but I'm sure Salpi has not. One of the main reasons Armenia did not ratify the Rome Statute was U.S. pressure. Back in 2000, under the Bush administration, the U.S. was against countries recognizing the Rome Statute, so that its forces potentially could be held legally responsible in international court, and conditioned military cooperation with Armenia and other countries by Armenia not joining the Rome Statute. That said, I have
in order to give that context, you have to say what the Rome Statute is and what the International Criminal Court is.
Well, the International Criminal Court would potentially sanction individuals for committing war crimes extraterritorially, and the United States, having its forces all around the world, felt at the particularly partisan level, or Republican Party level, that this might expose U.S. soldiers to unfair international prosecution, and made that a part of its policy to pressure other countries not to accede to this court. Now that said, U.S. still is the only country that has in the past imposed sanctions on Azerbaijan back in 1992, 1993. Those were fairly crude sanctions on the government of Azerbaijan, basically limiting assistance that could be provided to Azerbaijan, conditioning that by its policy in Karabakh. Of course, since then we've had a dilution of those sanctions. They are basically have been removed as part of again, Bush administration deal to be able to cooperate with Azerbaijan against terrorism. So we've seen since then had basically a relaxation of sanctions on Azerbaijan, but to this day we have that sort of the foundation for renewed sanctions against Azerbaijan. But of course, targeted sanctions under Magnitsky Act might be more effective. Right now, we have information. It's the crazy thing about this war and previous April war is how much information Azerbaijani government, Azerbaijani military have themselves published about their war crimes. Because in the context of Azerbaijani society, killing an Armenian in a brutal way, beheading an Armenian is not sanctioned by the government of Azerbaijan. As a matter of fact, seen as some kind of an accomplishment. So we've had individuals personally coming out and saying, yes, I cut off the head of this person, and I did this and I did that in this house. So we have that information. If that information is vetted, if that information is actually becomes part of U.S. policy discourse here, and makes it possible to sanction Azerbaijani officials, I think that would be a major accomplishment. However, we have not seen whether on the Armenian government's level or Armenian community level appreciation of this and an effort to really get U.S. government to act on this war crimes.
Sheila, are there other instruments, even probably dependent, nevertheless, on the kind of political backing that Emil just referred to. Are there other instruments we're not talking about that perhaps we have that have been utilized by the Armenian government that ought to be, can be utilized, or by not government, but again, civic initiatives in or out of Armenia? Are there other instruments?
There are many. I mean, I wouldn't say instruments, but mechanisms. There are other instruments. Actually, there's one more that I could mention that not that Armenia is putting it to use yet, but we saw in late last year that Armenia ratified the Convention on the Use and Recruitment of Mercenaries. And that was something that was done pretty quickly after the war began. And, we all know all the abundant evidence that there was of Azerbaijan using Syrian foreign terrorist fighters. Azerbaijan has been a party to this convention since 1989, funnily enough, so they've signed the convention that says they would never do this, yet they did it. But because Armenia wasn't a party to that convention, could not oppose it to Azerbaijan, could not accuse Azerbaijan of having, violated the convention. So signed on, came into effect December 23rd. And, pretty much that's sort of where we stand now. But as of December 23rd, this convention now applies to both parties and can be triggered at Armenia's will, if they would like to. I mean, there's a whole lot of issues around the timing of ratification, implications about whether, there's just whether it applies retroactively, but no. Then, in terms of most of accountability mechanisms, they're meant to be tailor-made. They should be tailor-made. And so there's usually, not most of them don't really look like one another. So I wouldn't say are there other instruments, but there's a whole host of different experiences that one could draw on and try to create a situation that is very unique and appropriate to this situation. And I think it will happen. It's just as Armenia is still in a state of shock, I think, and Azerbaijan clearly would not want something like this to happen. So this is where I think R2P would come in, and it should be the duty of the international community to step in and at the very least assist in forming some kind of mechanism to determine what happened and to reach some kind of accountability, reconciliation, and closure resolution. Not political, but in this sort of legal and victims-centered approach.
Irina, do you want to talk about other directions that are available to both, to Armenia and Azerbaijan, but to those who want to create this path to peace based on justice and equity? I have the environment in mind specifically, because that's something that you know well, that's an area you worked in, and whether anybody likes it or not, that is an area where there will need to be cooperation and collaboration, but again, unlikely to happen if there is not that environment of trust, which then goes back to justice and equity.
Salpi, it's a very complex question, because unfortunately we've seen that Azerbaijan deployed also incendiary weapons containing what doctors have concluded to be white phosphorus, based on the multiple burn victims that were admitted to medical facilities in Artsakh and Armenia following that attack. And if you followed the information coming out of Artsakh, it was pretty brutal in terms of how it was particularly targeted to burn vast swaths of forest. And as a result, close to 2,000 hectares of forest were burned. And Azerbaijani military officials were well aware that back in the 1990s war, Armenian fedayis were very familiar with the terrain. They use the terrain really well to conduct successful military operations. And they knew that because Armenian fighters know the territory really well, they would hide in the forest. So Azerbaijani forces used incendiary weapons containing phosphorus, and this actually constitutes, because forest is not a military target per se, that does constitute violation of respective convention, because incendiary weapons containing phosphorus or thermite are to be used only on military targets. In this particular case, these were used on forests, and they were targeting military personnel and civilians. So in this particular case, we see that Azerbaijan engaged in a military warfare, essentially committing ecocide, or a massive environmental crime that will have serious repercussions, because white phosphorus is a persistent pollutant, and we still have to assess what environmental damage we've seen, both to the soil and the biodiversity, as well as the water reservoir in the area and water resources in the area. I'm not hopeful on the part of Azerbaijan, because we also see that there's a clear signature to them already, even before the ceasefire statement was released on November 10th. There were certain dealings with a number of foreign entities to sell mining rights in different parts of Artsakh and surrounding territories. So it was clear that, one of the intentions of Azerbaijan in taking these territories is to exploit them for mining purposes, etc. Whether I see peace in this particular respect in terms of environmental management of these areas at this point, no, I don't see it. Not with this administration, or not until the tone is significantly changed, because every day we hear very bellicose, very aggressive statements from Aliyev personally and from his administration. They do not bode peace. They do not sound peaceful. It continues to be very racist, very xenophobic. And I believe that Aliyev needs to be put in his place. Him and his administration need to be tried, and justice needs to be sought for the war crimes that were committed. Only then, I believe, we can talk about peace.
Emil, you get the last word, and maybe part of your last word would address what Irina just hinted at, that is, Aliyev, the administration, the autocracy, the nature of the government and government-society relations, and how that impacts this whole conversation and all of our other conversations in terms of, building, I keep saying it, building that path to peace. And that goes through security, and that goes through trust, and that goes through justice.
Yeah, if we look at the situation in Azerbaijan just 6 months ago, we could see Azerbaijani leader Aliyev very much backed into a corner. He kept talking about people betraying him, including his ambassadors, his foreign minister, his other officials. It seemed like he was on the verge, in a sense, politically. That, I think, informed his decision to take this risk and go to war. And I don't think at any point at the beginning he was hoping to achieve the extent of success in terms of territorial advancement that he ended up achieving. But of course, you had sort of an unusual arrangement of Erdogan's support, Putin's neutrality, and a mess in the Armenian government. So that kind of a fragile arrangement, it will not be there for forever, and I'm sure he understands that. And that I think that also brings him to be a fairly not, this victory, it was not earned by him. He realizes that it's a chance coincidence of many situations that will not necessarily persevere.
I feel like we've only just scratched the surface, because each one of these opportunities, possibilities, and goals requires such a complex combination of skills, resources, participants. But even though we've just scratched the surface, I'm grateful to you all in any case. Sheila Paylan, Irina Ghaplanyan, Emil Sanamyan, thank you. And thank you to all of you for following this series, After War, Before Peace. we will continue because some of the things that we have not talked about at all are the relationships of all of the powers in the region and why and how they were both participants, observers, and now consequence bearing. Turkey, of course, Iran, Georgia, these conversations are still going to take place. Continue to follow After War, Before Peace, not just this video cast, but also audio podcasts on all of the audio channels. Thank you for joining us at the University of Southern California Institute of Armenian Studies.